Act 3 presents the government's witnesses. Each one will be examined by a prosecution attorney, followed with a cross-examination by one of the defense attorneys. On rare occasions, the prosecution may redirect questions following the defense's cross. David W. Chi received a Bachelor of Science degree in Physics and Mathematics from the University of Toronto in 2004, a Bachelor of Engineering degree in Electrical Engineering in 2008 from the Royal Military College of Canada, a Bachelor of Laws in 2013 from the University of Ottawa, and his J.D. from American University Washington College of Law in 2013. His associate work specialized in intellectual property and business litigation. He became an assistant U.S. attorney for the Middle District of Florida in November 2020. Mr. Chi will conduct the direct examination of government witness Patti Katter. Ms. Irvin will conduct the cross-examination for the defense.
Before the second day's session began, the court informed attorneys for both sides that juror number 12, Kenneth DeLallo, requested to be excused from duty following notice that his uncle had died. There being no objection, the first alternate, Jessica Norton, was moved into the jury to take Mr. DeLallo's place. Mr. Allen raised two concerns about government witnesses. He protested the introduction of a potentially prejudicial report containing allegations by the CFTC in their civil case against Michael DaCorta. Since that case was administratively closed and those charges not yet adjudicated, Mr. Allen argued that they should not be introduced at this trial. He asked that portions of page 16 in Exhibit 100A be redacted if that exhibit was allowed in. Mr. Chi told the court that the government would present a redacted version of page 16. The court felt that answered Mr. Allen's concern. Mr. Allen also expressed concern about government witness Ms. Sunu, a representative from the National Futures Association, whom he expected to explain what a pool operator is. Mr. Allen said he had been assured by the government that Ms. Sunu would not express an opinion that Mr. DaCorta's company was acting as a pool operator, to which Mr. Allen would object. His concern lay in expectation that the government was going to lay out this definition and potentially argue in closing that's what he was doing. He has not been accused of violating any of the NFA rules as part of the charges against him. Judge Jung responded by stating, "So I guess it's a relevance objection," to which Mr. Allen responded, "Relevance and 403 may be constructive amendment of indictment 2.
Mr. Allen was referring to Rule 403, excluding relevant evidence for prejudice, confusion, waste of time or other reasons, as well as arguing that the inclusion of the pool operator discussion could be construed as inappropriately amending, adding to the indictments being adjudicated there at trial. Rule 403 states, "The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence."
Oddly, though she had already spoken on the record, Attorney Bedke took this moment to apologize to the court, saying, "Your Honor, I apologize that we are straggling in. I guess I understood that the jurors were supposed to report at 8:45 because we were going to start at 9 o'clock. To which the judge responded, "You're good." This brief exchange was then followed by Mr. Murray introducing a clerical matter, unrelated to the pool operator thing, as the judge called it. The judge was not so easily put off of Mr. Allen's concern. Hereafter we record the rather disturbing exchange that followed in a pre-session discussion.
While we're waiting, Mr. Allen had sort of a 403 relevance objection to your expert saying what a pool operator was. And it's my understanding she is going to say what a pool operator is, or what constitutes that, without opining that Mr. DaCorta was one. Is that generally correct?
Correct, Your Honor.
All right. Mr. Allen, I would rather take this on the fly.
That's fine, Your Honor.
What are we talking about, a swimming pool? I am so green to this case that I'm just not real comfortable making a ruling notwithstanding these very clear openings, how it fits and all that. So let's just take it on the fly. And if you have a problem with a contemporaneous objection from the bar, then you can come sidebar.
Yes, sir. That's actually going to be Mr. Rosenthal. He will make that contemporaneous objection. Thank you.
Your Honor, I'll just add for the record in our expert disclosure to which there is no Dober motion objection. We disclosed that she was going to be testifying about the regulatory framework, what commodity pool operators are and commodity interest pools are, why they are regulated. So this isn't—
Ready? Bring them in. And I think I understand the gist of it. Let's just take it on the fly. Sometimes these things are not quite as pointed and prejudicial in real time as they appear, and maybe it will be worse.
The Dober motion that Mr. Murray referred to is a type of motion which seeks to exclude the presentation of an expert's testimony to a jury. Dober motions are named for the Supreme Court case Dober v. Merrill Dow Farm, Inc. Since the defense made no Dober motion to exclude or qualify Ms. Sunu's testimony, the specific factors defined in Dober became moot.
I don't know what they have to say. It makes no difference anyway. Whatever it is, I'm against it.
Mr. Allen was concerned that a central issue in the civil case, that Oasis was charged with operating a commodity pool, might, through the testimony of Ms. Sunu, be slipped into these trial proceedings. Because the charge of operating a commodity pool was not part of the criminal indictment against his client, Mr. Allen's concern was justified. Importantly, he worked to prevent the question being raised so that it could be properly addressed in the civil case without reference back to this criminal trial.
These proceedings are not about that.
The government's second witness was Mrs. Patti Katter. She and her husband were Oasis lenders.
Mrs. Katter established that her husband suffered brain injuries during a 2007 tour of duty for the U.S. Army in Iraq, a fact she repeatedly referred to throughout her testimony. Consequently, he had several surgeries and was medically retired from the military in 2010, and had since been unable to work. She told Mr. Chi that she is the primary breadwinner for her family, and supports it through a podcast she hosts and work she does part-time. Throughout her testimony, she never missed an opportunity to reference her husband's wounded condition or her own pitiable circumstances. In this respect, as evidenced by her self-aggrandizing website, pattikatter.com, YouTube channel, Facebook pages, Instagram, and Apple Podcasts, she is a well-practiced professional victim who covers her alleged sufferings with shows of bravery and fortitude. She stated that she and her husband met Michael DaCorta in 2017 when he attended get-togethers with mutual friends, though when asked, she was not clearly specific about any particular such event other that they attended the Oasis 2017 Christmas party. Here is one of the many shameless self-promotions found on Patti Katter's Facebook page, showing a hypothetical package boasting inclusions of ass-kickin' shoes for veteran advocacy, a bubbly personality, and podcast microphone in an adult-size costume. Costume indeed. Patti claimed that she and her husband became friends with Mike DaCorta, and that her husband and Mike had become really good friends playing pickleball. In conversations out of court, Mike confirmed that he and Mr. Katter had played some pickleball with each other, but strongly disputed that he was a good friend of Mr. Katter, or that he had more than a passing acquaintance with Patti. When asked what types of social activities she and her husband participated in with Mr. DaCorta, Patti could not be specific. In response to a question about the 2017 Christmas party, Mrs. Katter stated that it was for his current investors and people interested in investing in his company. At that time, the Katters were not investors. Mrs. Katter could not recall how or why they were invited, but she was very descriptive of how eloquent and extravagant it was. There was a lot of money at that event, she said, and estimated that there were a few hundred or a couple hundred people in attendance at it. She thought it more extravagant than any White House or military ball she had attended.
I find it hard to believe.
Given this photo of the Katters at a Watergate Hotel gala in Washington, D.C., we find her statement about the extraordinary extravagance of Oasis's 2017 Christmas party hard to believe too. Even though it was taken a few months after the trial, this photo is likely representative of similar celebrations the Katters attended in line with the work Patti professed doing for the Elizabeth Dole Foundation. Patti learned about Oasis through discussions with friends in 2017. Following the Christmas party and after a couple months spent deliberating with one another about whether to join the Oasis loan program or commit their money to some other form of investment such as stocks, in February of 2018, the Katters visited Mr. DaCorta at Oasis's offices in Sarasota to obtain more information about the OIG loan program, which by then was well underway. She stated that they talked extensively about how important the money was to them. At first, they were thinking of placing only $25,000 of the $100,000 they had saved into the Oasis loan program instead of the stock market. But after talking with Mr. DaCorta, they decided to loan the entire $100,000 of savings. She repeatedly stressed how the loss of that loan was devastating to her family. Another self-promotion on Patti's Facebook page.
I had some money put aside. From when my husband was wounded in war, he received something. It's a benefit from the military. So it's part of a life insurance plan, but if you are wounded in war, you can receive money. It's TSGLI is the acronym for it. Ken received $25,000 of that. And then unfortunately in 2015 I lost both of my parents. They passed away. And my dad had set aside a significant, I say significant. It was significant to us. It was an amount of money that he set aside for me to be able to make our family's life better for our kids. It wasn't that much, though.
What can I do to show you how sorry I am?
And how much money was that?
The total for that was $100,000 that my dad left me, but we spent some of that on another place. So basically, we had $100,000 from when my husband was wounded, the $25,000, and then the $75,000 was from when my dad passed away.
Despite the severe financial constraints Patti Katter testified to, when filling out the financial disclosure form required by Oasis, she stated that she was earning $54,000 per year and had $120,000 of capital to put at risk.
Well, we were hoping to find a good way to make money off of it because my husband basically lives on disability, and it's my responsibility to bring in money. So I had debated back and forth like with the stock market. I actually met with some people from a company who sells stocks and decided that's not a good idea. I waited over 2 years until we became friends with Mike, and I thought that I could trust him. I explained to him that, again, that this is a lot of money to us. And so we decided to invest with Mike because he was our friend.
Now, turning your attention back to that 2018 meeting, what types of questions did you ask the defendant about Oasis?
I asked Mike how I was actually really concerned about losing money. I didn't want to lose money. Mike, how strong is this? And he assured me that it was a really strong investment, that there was virtually no way that we would lose our money unless the entire global economy collapsed.
Were there any guarantees made to you with respect to the performance of your loan monies?
Yes.
What were they?
He said that we would be making about a 12% interest.
How did the defendant characterize that $100,000?
As a loan.
And what did you understand that to mean?
A loan with interest.
What would be the interest that you understood?
So the interest would be, it should be at least about 12%. It depended on the currencies, but it would be never less than that amount.
Ms. Katter, what is Exhibit 200A?
It is the promissory note and loan agreement.
I would like to turn your attention to the first paragraph on the first page of Exhibit 200A. What is the amount of the loan amount?
$100,000.
And whose name appears in the sentences before $100,000?
My husband and my name.
Now, turning back to page 1 of Exhibit 200A, I would like to turn your attention to the first paragraph, the heading Interest. And what is the interest amount noted on Exhibit 200A?
12%.
What, if anything, did the defendant tell you about that 12% interest rate?
That we would be guaranteed to receive 12% at least, if not greater.
Now, did you eventually receive a copy of the loan agreement and promissory note?
Yes.
Now, Ms. Katter, how did you understand that your loan monies were to be handled?
I just figured that Mike was trading and buying, selling currencies for us. He mentioned on the day we met with him in Longboat Key that they were doing it around the clock, 24 hours a day, 7 days a week.
Would you have provided a loan in that amount of $100,000? Had you known that monies would be spent on properties or cars?
Never in a million years.
Or invested in other businesses?
Never.
Mr. and Mrs. Katter signed the exact same promissory note and loan agreement as all other Oasis lenders. If they had not done so by March 2019, a month before Oasis was shut down by the government, their money would have been returned, and they could not have accessed the back-office information displayed for their account, which Patti acknowledged she frequently reviewed. The note included an agreement and risk disclosure section. Paragraph 3 of that section reads in pertinent part as follows. Use of funds. At any time in Oasis's sole discretion and without prior demand or notice, Oasis may use any or all money loaned by lender, including any interest thereon, for any purpose whatsoever, including without limitation any investment, the purchase or sale of any business's assets or liabilities, the purchase or sale of any real estate, or for any other purpose. Lender hereby agrees that Oasis may, in the sole discretion of Oasis, apply and transfer from any of lender's funds with Oasis to any of Oasis's other accounts. Lender hereby authorizes Oasis to use any money loaned to it by lender, including any interest thereon. Oasis shall have the right to use any money loaned to it by lender, including any interest thereon, free from any claim or right of any nature whatsoever of the lender.
Ms. Katter, how did the loss of the loan amount that you described affect you and your family?
Well, I still am trying to make up for lost time. I was trying to make up for lost time when I met Mike. When my husband was wounded in 2007, it was already difficult. Then he retired, and we discovered that our income was significantly less than what he would have made in the military. I spent years with Ken in hospitals and doctor appointments, as did my kids. I took them out and homeschooled them in doctors' offices and hospitals. I didn't have time to work full-time while I was trying to take care of my husband. I didn't have time to save money for college for my kids. I didn't have time to try to make money for weddings, for cars, for my children to help them with the little things. There were times that we spent living paycheck to paycheck. And I finally, after my dad passed away, we had this little cushion that was taken from us. And still to this day, I'm trying to make up for time.
Ms. Katter, did you receive any of the loan monies that you provided to Oasis back?
What can I do to show you how sorry I am?
He explained to you that the way they are able to make money for lenders is through the volume of foreign currency trading.
Yes.
And he explained that if you are interested in this program, then you would be loaning this money to OIG. Is that correct?
Yes.
And once you emailed Gil Wilson, you actually received the promissory note within a week from John Paniagua. Is that correct?
Yes.
In that promissory note, it did set out what the terms of the loan agreements were. Is that correct?
Yes.
What I wanted to make sure that you understood from reading this loan agreement, this promissory loan, is that the agreement was that you would get 12% per year on your loan. Is that correct? Your understanding of it was that you would get 12% of your loan per year as interest?
At least.
Mrs. Katter acknowledged that the $100,000 she invested in Oasis was a loan guaranteed to earn at least 12% a year. On cross-examination, Ms. Irvin should have amplified this by asking the following questions. Do you agree that you loaned $100,000 to Oasis? She'd have to answer yes. When you loaned that money, you received a certificate for it from John Paniagua in the form of a promissory note and agreement, which set out the terms of the loan, correct? Yes. When you loan money to a bank, you get a similar certificate for your loan called a Certificate of Deposit, or CD, which states the interest the bank will pay for the use of your money. Would you agree that whenever someone loans money to another party, that it's prudent to get back a certificate describing the terms of the loan and the amount of interest to be paid for it? Yes. The promissory note and agreement that Oasis gave you in exchange for the use of your money guaranteed a return of at least 12% per year, correct? Correct. Did the promissory note give you permission to know anything else about the operations of the company? No. You testified that if you had known that Oasis was using your loan money to buy investment real estate or businesses, that you would never in a million years have provided them your money, correct? Correct. Yet the promissory note that you signed clearly stated that Oasis could use your loan for anything it chose to. Its only obligation to you was to pay you at least 12% per year on that money. Why did you not carefully read Oasis's own disclosure under paragraph 3 entitled Use of Funds before giving the loan to Oasis?
I want to fast forward a bit to December of 2018. I believe you may have received an email from Joe Paniagua letting you know that they were updating the back office website.
I don't remember what month it was. But yes, they sent me an email saying that they were updating the website.
As part of the updating the website, they were also updating their loan program. Do you recall that?
Not off the top of my head.
Okay, if you wanted to continue to participate in the loan program, then you would have to go through a new process of setting up basically a new account. And that new account would be a part of this updated back office. Do you recall that?
They did not tell me that. They just said they were working on a new website that I recall. I don't recall that. They were working on a new website and they just needed more information from me so that I could log in and create a new password and username for their new website.
Mrs. Katter stated that Oasis needed more information so that I could log in. Miss Irvin should have pressed this point by asking her whether or not she could have continued to log in without providing that information. The answer was no, and defense counsel should have been prepared with the correspondence from Oasis office manager Deb Cheslow that Mrs. Katter referred to. In late 2018, Deb began informing all lenders that they had to update their online profile, or they would not be able to log in. Their account would be closed and their money returned. In fact, that's exactly what did happen. For those who failed to timely update their information, access to their online reports was suspended in January, and in March of 2019, their account was closed and all funds returned. Defense counsel should have known this.
You recall going through the process of creating that new website, that information, I should say, for that new back office account?
The only thing that was different that stuck out in my head is somebody did tell me that during the new website they needed a copy of our passports. So I thought that was weird, but other than that, the only thing that I really had to do was log in. We did the same thing. Put our social security number in, I believe, update our, make sure our home address is still the same, just like you would with any new website.
And then, looking at a document I put in front of you, does that help you? If you look through each of the payables, does that help you recall providing this information so that you could have an updated account on the new back office website?
Yes, I just figured it was just like a regular website. You have to fill in the blanks before you can access your own information.
So do you recognize this document now that you have had a chance to review it?
Not exactly, but it makes sense to me that I would have filled it out. It just looks like all of my personal information. Oh wait, yes, I do because I see the signature, and I do remember having to fill. I didn't have a signature pad. That's why I remember it.
And it shows your estimated annual income at the time was $54,000.
Yes.
It shows your net worth is $500,000?
That includes if we sold our home, yes.
And the risk capital that's listed there is $120,000?
Yes.
It shows retired, and I'm assuming that means that your husband's retired.
Yes.
It shows that you were employed at the time?
Yes.
You are employed as a receptionist at Sarasota Facial Aesthetics.
Mrs. Irvin should have asked, given your repeated testimony that the money you loaned was essential to your family's financial stability and well-being, why did you put on your Oasis financial disclosure that you had $120,000 in capital to risk? Under the dire circumstances you described to Mr. Chi, was it sufficient to simply trust all that money on the unrecorded word of a man you barely knew?
For the secondary signature, do you recognize that signature as yours?
Yes.
Do you recall that you learned that federal agents had arrested Mr. DaCorta in April of 2019?
Yes.
Do you recall that you learned that federal agents had seized all of OIG's assets?
Yes.
including your money?
Yes.
Afterwards, that same month in April of 2019, you were interviewed by Agent Sean Batch, correct?
Yes.
And he told you that Oasis was a Ponzi scheme?
Yes.
And you believed him?
Yes, there was enough evidence in my opinion.
Is that it?
No, there's more.
Can I say something? I don't know if he used the word Ponzi scheme. He said Mike was in big trouble because I just didn't recognize the word Ponzi scheme. Now that I think about it, it was later on when I was researching what it was called that we were told. But when they came to the house, they did say that Mike was being investigated because he didn't use our money the way that it was supposed to be used.
Ms. Irvin should have asked, what were you given that convinced you there was sufficient evidence that Mike had not used your money in the way it was supposed to be used, and who provided that evidence to you? Reflecting now on the terms disclosed in your promissory note and agreement, which, as we've seen, clearly states that Oasis had full discretion to use your loan money for a very wide selection of investments, and given that they had no duty to disclose those uses to you so long as they met their obligation to pay you the guaranteed interest of at least 12% per year, do you still feel that the evidence given to you was wholly adequate for you to conclude that your money was not used by Oasis in the way it was supposed to be? Finally, Miss Irvin should have concluded by asking, you have told us that you never tried to withdraw any money from Oasis. Do you know of anyone who did, or of anyone who was prevented from doing so? Is it possible that access to your funds was not prevented by Mike DaCorta nor Oasis, but was in fact blocked by the government's interruption of Oasis's business, and the seizing of its assets before there was ever a trial, where a jury was given sufficient evidence to decide that Oasis had done something wrong?